Good morning, everybody. This is Mike Weaver from Quarles and Brady. I'm on the phone this morning with two of my partners from the employee benefits practice, John Barlaments and Carolyn McAllister. We're going to cover a few different areas, both on the retirement plan side and the health and welfare plan side. Just a quick overview. We're going to talk about an overview of the CARES Act changes, what I have referred to as the $100,000 question relating to distributions and loans. Some cost containment options for plan sponsors, how the suspension of required minimum distributions in 2020 is going to work, treatment of various leaves, layoffs, furloughs, and some of the meaning behind those terms and how they are commonly used, and tax and amendment deadlines. After Carolyn and I will be covering those topics, John will be covering some of the topics on health and welfare plans, continuing health benefits during furlough, health and welfare plan considerations, and resources for employers. So with that, I think we'll move to the next slide here. And I will turn it over to Carolyn to give us some of the background.
Thanks, Mike. So many of you are likely familiar with the retirement plan and other provisions under the CARES Act. I just wanted to cover this, just spend a few minutes for those, since we have a number of people on the call today that may not be as familiar. And if you can believe it, that this only happened 2.5 weeks ago. I know time seems to be a little different these days, but just to make sure that we're all starting on the same page, I'm just going to go over the 4 different provisions related to retirement plans that are in the CARES Act. And the first one that is about, these are directly impacting participants, distribution, and loan options. So as the slide has, what we're really focused on here is what is a corona-related distribution or loan. And if a participant, spouse, or dependent is diagnosed with coronavirus, then that's one of the reasons that you could be eligible for these distribution or loan options if your plan allows. The other trickier piece is the second prong here, where it says there's an adverse financial consequence as a result of being quarantined, which is, quarantine is a little different than just these stay-at-home orders that we have, or has had their work schedule affected due to the virus, or is unable to work because of lack of childcare. And then the next thing is that, how are we as plan sponsors going to know if an individual would have a corona-related situation? And the CARES Act provides that a plan administrator can accept the employee's self-certification that the distribution or loan that they're requesting is coronavirus related. And then obviously this affects 401k plans, 403b plans, IRAs too, not the loan provisions, but the distribution provisions, and then governmental 457b plans. So more specifically to the distribution options, so the CRD, the coronavirus-related distributions, must be taken before the end of 2020. There is an aggregate limit of up to $100,000. And then what makes these distributions different from other types of relief we've seen is that they will not be subject to the 20% withholding. So instead, there's a voluntary 10% withholding, which means that employees can opt out of withholding and receive the entire distribution amount. They will not be subject to the 10% early distribution tax that would apply if someone is under age 50 and a half in many cases. And then the last 2 bullets here, that the income tax incurred from these distributions can be spread out over 3 years. So someone wouldn't have to take the tax hit all in 2020. They could take a third of it in 2020 and then 21 and 22, and also have the option, not that we really see a lot of people being able to do it in these circumstances, but have the option of being able to repay those amounts back to the plan or an IRA within 3 years. Now, as far as loans, there's a shorter period of time, not until the end of 2020, but until September of 2020 in order to take a loan related to coronavirus condition. The rules under the CARE Act increase the amount of the loan. Normally, they're limited to 50% of your account or $550,000. For the next 180 days, it goes up to $100,000, and there is no limit. A participant could take 100% of their vested account balance. And there's also special provisions that allow for the repayment period for suspension of loan payments and the repayment period to be extended by 1 year so that people won't have to start making payments until 2021. And then the other two provisions in the CARE Act that we wanted to mention is the required minimum distributions, that there's a waiver of the required minimum distributions for 2020. We saw that back in 2009 when, because the market has been taken a huge hit with all of the changes that we've been experiencing. They don't want to require people to take their sorry about that. For the slide, they don't want to require people to take their minimum distributions this year. So there's a provision in the CARES Act that's been waived, and we'll talk about that a little more later. And then the last item to mention, funding relief for defined benefit plans. This offers plan sponsors a little bit of breathing room, again, because of the stock market being down and all the different financial situations companies will find themselves in, that there's a delay, that they can delay any contributions that were going to be made in 2020 to the beginning of 2021. So if for cash flow purposes, if you need to delay your contributions, then this provision will let you do that. And also you can, instead of kind of locking in those losses for your funding status, plans can rely on the funding status from 2019 so they won't end up having to restrict distributions. I mean, this isn't likely enough relief for defined benefit plan sponsors, but it's something, I guess, for the interim cash flow purposes that companies won't have to worry about that right away. So then we're switching over back to you, Mike, for your $100,000 question. Are you there, Mike?
I am. I'm having difficulty on the screen. I don't know if people can continue to see the screen at this point. If not, please tech people, if you could help us out, I'd appreciate it. So what I've referred to as the $100,000 question, this is really a question we've been getting from a lot of our clients already so far, and it's the what should we offer and what shouldn't we offer. Should we offer loans? Should we offer the distributions, or should we offer both of them? I think a lot of plan sponsors have really been asking about loans in particular. What about loans? And the issue that's coming up that we're concerned about, we've seen plan sponsors raise concerns about with loans is it's all well and good that the money's coming out now. People are able to get their hands on the balances of their retirement plan and cut off the short-term issue. But loans, being what they are, will ultimately need to be repaid. And when you think about it, if someone actually did have an account balance of $100,000 or more and was able to take the full loan, you're looking at a pretty substantial monthly payment, really coming off of a time when people are already have their belts tightened. So there's a significant risk that the loan could run into a default situation, I guess is our thought. And one of the complications of a default situation, of course, is if you go into a default situation, you're not necessarily going to have the benefit of the 10% penalty tax relief. The 10% penalty tax relief that Carolyn spoke of earlier relates to distributions taken during the remainder of 2020, and so if you have a loan that someone takes now and says, I think I'm all set, and about a year or two down the road, it goes into default, you may be looking at $80,000 of taxable income and getting slapped with another $8,000 on on top of that, it really can be pretty brutal for employees. What we've talked about internally here is maybe distributions are kind of like a mini loan, so to speak. That means being that really you have the time when you have the money in your hand right now. You have 3 years to pay it back. You're not paying any interest on it. You are out of pocket the tax, potentially 1/3 for your tax that you'll be filing in April of 2021, 22, and 23. But if you make the repayments, you will, according to the way the law is drafted, you'll be able to get the money back. Those repayments will effectively be treated as rollovers. So a lot of employers, I would say half of the ones that I've talked to, and Carolyn's certainly interested in your perspective from many of the clients you've spoken to, really, I'd say about half the clients that I've worked with have said, well, we're gonna definitely do the distributions, but we're not so sure about the loans. So it's something to think about as we go down the road here. So a little bit more depth on some of the things that we covered earlier in Carolyn's comments here too. One of these amounts allowed. Clearly, the adverse financial circumstances relates to the participants. We've gotten questions about what about somebody else? What if you have a 2-income family and the participant at your organization, they're able to keep their hours up and keep going, but suddenly their spouse, who has been bringing in half of the household income, loses their job. Is that an adverse financial consequence to the participant? Like any good lawyer, to some extent, we have to say we don't know for sure. I know the conservative approach is to say that that is not an adverse financial consequence, and to some extent, we may have to keep our eyes out for the guidance, which seems to be coming at an alarmingly fast rate, almost from the IRS and Department of Labor, to see if we can get to a point where we get comfortable that the spouse's loss of their job would have an adverse financial consequence on the participant. As Carolyn indicated, it is self-certifying, and so that does give a certain amount of comfort there. I think, again, is the IRS likely to be heavy-handed on this? We would certainly hope not, given the fact that it's really designed to be a very friendly provision, giving people an opportunity in what is otherwise a desperate situation. But kind of stay tuned on that. So when to adopt, the last thing I wanted to cover on this slide, immediately versus wait to see what participants need and request. Our experience has been that a lot of the TPAs have been going out to plan sponsors right away now and handing checklists to them and saying, tell us whether you want loans, distributions, or neither or both. So the provisions themselves, the implementation is likely on a pretty short order. And of course, that kind of goes logically with the fact that people are today, as days go by, getting furloughed, laid off, having their hours cut. So practically speaking, the implementation of the provisions probably should be a today type item. Wait to see if participants need a request. I think it's an option. The challenge is you will likely be in line behind all the people and other plan sponsors that said, let's go with this right away, versus getting in front of your TPA today and trying to get your implementation in the queue for getting it out there and ready to go on your participant website. I'm going to move on to the next slide here. So if someone has the ability to control the slides, again, I apologize that I'm not able to directly here. And then I guess talk a little about who to cover: active and terminated participants, beneficiaries, and alternate payees. I want to focus here on the who to cover slide to talk about that this can work for both active and terminated participants. We certainly want to be thinking about terminated participants here. Active, I think the law is very clear that you're going to be able to take distributions from plans at a time that you might not otherwise be able to. Terminated participants, while often they have the ability to take money out already, the key thing there is probably with terminated participants still, if it's possible for your TPA to get a certification that the amounts are coronavirus related distributions. And the reason being is for people who are taking them, they want to avoid that penalty tax and have the ability potentially to repay it down the road. How that's going to shake out when it comes to reporting isn't clear yet. The IRS tends to deal with some of that a little bit further down the road. What we want to be able to do right now, though, is to gather the information necessary so that we can do the reporting in an appropriate way. And whether people will be getting a single 1099-R to report their distribution for all years, or whether they'll be getting a separate one each year, we don't know right now. We suspect, based on other situations, that you'll get a single one and it'll be your responsibility to report your tax over the 3-year period. But again, to some extent, that's something that we'll have to wait and see on. What contribution sources to make available? Employee contributions, I think that's sort of a slam dunk. Employer contributions, that's one that at least it's a pump the brake to think about for a second. And that comes down to a bit of an employer thought process, I guess. Having people get their own money back, that's really what we've always been doing with things like hardships and loans. Hey, your money will be available to you. If you really need it, there are a few ways you can get at it. Employer contributions, employers look at this money as money that's preparing the participants for the long run in retirement. When money goes out as a distribution, there is the risk of what people used to always call leakage, that the money will never come back. So it's a bit of something that employers want to think about a little bit, and in whether it's something they want to open up for all sources or not. Not an easy answer on that one, because the people who need this really need the money. Limit to 100% vested sources. Ideally, yes. Practically speaking, probably not going to be possible, just because people, if they need the money and they're 50% vested or 75% vested, the idea of saying, sorry, you can't have it, really doesn't play well. Now, that adds to some complications potentially down the road when it comes to vesting and distributions. But TPAs your third-party administrators deal with vesting issues. They have formulas that they can use in their system. So I think that's probably more of a practical question, and having TPAs deal more with partially vested distributions than they do in other situations where there's hopefully further employer money coming in down the road. Exclude sources regarding spousal consent. Another interesting sort of topic. Spousal consent can complicate on these things. It's interesting to read the law. There's one reading of the law that would suggest that spousal consent isn't even necessary. I think that's an aggressive approach, and I don't think most plan sponsors or attorneys out there would recommend you go there. I think if you've got a source like a money purchase pension plan source where you need spousal consent, it's probably advisable to get spousal consent. But it is also interesting to note that these distributions are not limited to strictly employer profit sharing 401k matching contribution sources where no spousal consent is required. And so finally, you're going to need to check with your plan's record keeper on what their platform allows and work with them through them. I think it's especially the case on the spousal consent sources if you have significant assets that require spousal consent. And in particular, if you've got if the participant can't get $100,000 worth of distribution from the other remaining sources. Next slide, please, for someone who would be controlling the slide. We talked a little about already here with the risks of loans. No 10% penalty penalty waiver if you don't pay them back, and the high payment. You could be looking at $1,300 a month or more if someone took a $100,000 loan. The risks are much smaller with with distributions. And one or two additional things that we didn't cover earlier. Multiple withdrawals allowed. Now, this potentially creates an issue if people are coming back routinely. I think a lot of plan sponsors have turned over the withdrawal function to their TPAs, the approval of standard type withdrawals, and in this case, the certification will presumably be simply checking a box on the form requesting a distribution. So multiple withdrawals won't create some of the complications that might have 10, 15 years ago, where plan sponsors were typically much more involved in the distributions. And as an added bonus, I think a lot of TPAs have decided to waive distribution and loan fees for the time being. So that also takes away one of the costs that might otherwise visit itself on participants who are trying to get their hands on their distribution or on their plan assets, on their accounts. Then if we could go on to slide 11, please. So what about hardship withdrawals? Won't hardship, this is my last slide, then Carolyn, you'll be taking over again. What about a hardship withdrawals? Can hardship withdrawals cover this? Maybe. The challenge with hardship withdrawals is that while they aren't limited to the $100,000 limit here, they are going to be subject to the 10% early distribution penalty tax. And participants have to live in or work in a FEMA declared disaster area. Very recently, though, each state in the United States, apparently for the first time in history, has been declared a federally declared disaster status area. So one of the impediments that was out there early on in these coronavirus distributions, if you didn't have the benefit of the new law, has now been taken out of the way. Every state is considered a disaster area for this. But the real catch here, of course, is there's no ability to spread the tax or repay the distribution. And again, the 10% early distribution tax would nick you. So that's really it on hardship withdrawals. Finally, are loan suspensions optional? Just very briefly there. Some people say maybe. I guess our take, and again, Carolyn, certainly would welcome any thoughts you have as I turn this back over to you. We don't see a lot of reason not to allow people to do loan suspensions. And the reason being is we're based on what seems to be a fair reading of the law, and frankly, the law was written under pressure, so some things may not be as perfect as Congress would otherwise hope. It certainly looks like what we're going to end up doing is pushing back payments a year. The principal will continue to accrue interest, but other than that, it's really just pushing payments and the deadlines out a year. So if someone really wanted to keep paying down their loan, they can work with the TPA to continue to pay down the loan and keep it on track as it was. So with that, I think, Carolyn, I'm going to turn it back over to you for slide number 12.
Thanks, Mike. There was one question that came in, so maybe I can hold you for one more question because I thought this one was interesting.
Of course. Yes.
The question is since it is becoming common to implement temporary pay reductions, would this qualify for a distribution option reason? So if the employee isn't laid off, but they have a pay, or their hours aren't reduced, they just have a pay reduction.
Just a straight up pay reduction. I think. Well, I'll tell you what, Carolyn, while you cover your slides, I will get an answer to that. And when we return to me, I will have the answer. I want to take a look at something.
Yeah, right. That's not a straightforward one. Okay, sounds good.
Okay.
Sure. So then the next thing we wanted to talk about is kind of some cost containment strategies. And some employers that we work with these are some of the first questions that they had asked about just trying to figure out their options going into a potential recession and maybe cash flow issues. What do we need to think about if we're going to reduce employer contributions now or suspend them for the rest of the year? And some employers, like I said, looked at that right away. Others, might have had other things they were working on right away, and they're now starting to think about this. And the options that are available, or like the process that you have to go through and how you can implement it, really depends on the terms of your plan. So obviously for safe harbor plans, there are specific requirements under the regulations on how you can make changes. For other plans, there may be more flexibility, but you still need to look at your plan. And so this slide just has provisions on things to think about and look at as far as how would you to consider if you're going to consider reductions or suspending contributions. So do you have a stated formula, or does your plan say that contributions are completely discretionary? Would you want to suspend matching contributions, or maybe just profit sharing and non-elective? Does your plan provide for payroll period matches or payroll period profit sharing contributions, or are they plan year? And then how do you want to eliminate it? And with the 401A-17 limit, that's the limit on how much compensation plan can take into account for the year. So for 2020, that's $285,000. And if you were to make a change in contributions effective April 1st, then you would need to look at or at this point, maybe on May 1st, you need to take a look at how much of the 401A17 limit applies for those first 4 months, and then see what's the maximum contribution you can actually make to certain individuals. Some payroll systems may take that into account and others don't. But again, so it's something to think about. And again, just go check the terms of your plan. And also watch out if you were thinking about getting an employee retention credit under the CARES Act. There is a concern about whether you need to have at least 90% of your workforce retained at full benefits and compensation. And we don't know at this point if there was, if it was a discretionary contribution, maybe that wouldn't impact this requirement. But if you had a safe harbor plan or you had another match stated in your plan and then you took it away, could that impact something here? So just to be aware of. So then turning over now to safe harbor 401k plans, the first question here to ask is, did you send out your safe harbor notice last year with the language allowing you to suspend contributions with 30 days? If you did, then you have the ability under the regulations to go ahead and suspend it. If you didn't, then there's a harder road that you need to go through as far as showing that you have an economic loss and meeting other criteria in order to suspend safe harbor contributions. And then on the very extreme side, then you could potentially terminate the plan, but there are also requirements for that you need to. And Congress hasn't given us any relief from the safe harbor requirements. If you want to do any of this, it would be nice if the IRS would change the 30-day notice or give some other type of relief, but we really don't have anything here. So it's basically as if in any other year you're going to stop safe harbor contributions. Those are the rules. So there's, like it says on the slide, there's a 30-day notice required, and you need to adopt the amendment before it's effective. So if you're thinking of doing this, this is something that you need to think about at least 30 days in advance, or probably even more so than that, to get everything ready. You also need to obviously fund the contribution through the effective date of the change. Because your safe harbor will be gone then for 2020, you'll have to do all the non-discrimination testing, the ADP, ACP testing, and there's a different commentary out from law firms too on this top-heavy provision. You'll also lose your top-heavy your top-heavy exemptions. So that could, for employers that would have problems with being top-heavy, if they don't have the safe harbor, this may or may not actually work to suspend it, because then you'll still end up having to make the top-heavy contribution. And then now for, so if you're not in a safe harbor plan, there is some more flexibility in what you can do. For one, so these are some kind of options to consider, whether you would want to just freeze for the remainder of this year, and so make contributions for the first quarter and then freeze for the rest of the year, or if you have a plan that has a last 8,000 hours requirement and there isn't an add-day cutback reason why you can't actually just change the formula for the entire year, then you could potentially not make contributions this year. And the third bullet point too, just if you just needed to change the timing of funding, like maybe historically you've done funding of contributions on a payroll basis, but now you want to change to an annual contribution, just check the terms of your plan, and maybe you can just change the timing of the contribution to ease cash flow. Again, you generally need a plan amendment to do any of these things and provide some type of notice to participants. And depending on your language, whether or not you're doing it prospectively or you can freeze for the whole year, you may still need to make contributions up until the date that you make the change. And we've also seen this last one, I've seen employers where, and this is just not even for this reason, but for other reasons, where they just want to stop making contributions for the second half of the year if they've done it on a payroll basis. And, depending on the terms of your plan, if you made a profit sharing contribution for 4 months and now you just want to stop, and your plan has has a profit share contribution based on a year worth of compensation, you may need to make adjustments and reallocate that contribution so everybody gets like the right percentage of it. So that's something to think about. If you're making a change mid-year from what you're doing, you'll have to go back and make sure that whatever contribution you do provide matches with the terms of the plan. So then moving on now, I guess it's back to you, Mike, then for required minimum distributions.
Thank you. Yeah, I did do, while we were talking here, it is a very interesting question, Carolyn, that our participant raised, because the law as written really suggests that you have to have either be quarantined, furloughed, laid off, or have your working hours reduced in order to claim to be able to make a distribution request. Now, the good news, if there is good news or silver lining in that, is the IRS does have authority under the law to expand on that. Including, as it says, your other factors determined by the Secretary of the Treasury or the Secretary's delegate. So I think the short answer is right now, I think that would be a stretch if it's just a straight up reduction in pay. But I'd remain somewhat hopeful that, like the participant's question suggests, there are situations where the employer is actually trying not to cut people back, but simply needs to take make a financial adjustment, hopefully in the short term, to keep everyone fully employed and keep the business running. So not the answer, I'm sure, that we'd hope for, but I think the answer where it is for the time being. That said,
Mike. Oh, Mike, I was going to say, when I saw that too, I'm thinking this is something that Congress probably really wasn't considering when they adopted the provisions, and hopefully the IRS will give us more guidance, because this feels like it should be a situation just as if you were reducing your hours and reducing your pay. Just reducing your pay, is likely within what they meant to cover, but that's not what the provision says right now.
Sure. Okay. All right. So we have a question that we'll come back to here that Meg just forwarded on to us. But I'm going to go ahead and address the RMD suspension here, and then we'll come back to the question. So 2020 effects. Let's talk about suspension for required minimum distributions. Carolyn talked about this a little bit earlier on. The issue here is people are receiving required minimum distributions. In fact, some of them probably received them within the last few weeks. Related to people who were first required to receive a distribution based on being 70 and a half and terminated during the 2019 calendar year. And the deadline for those distributions would have been April 1st. Of course, this law coming out in March, as it did, really didn't give a lot of opportunity to change direction for people. And in fact, it came out after a lot of people would have taken the required minimum distributions for the year. So let's talk about the various scenarios and kind of where we feel they're going to land for right now. If you were to have taken out your required minimum in 2019, which you're permitted to do for your initial required minimum that's otherwise due on April 1st of 2020, you're out of luck. Those aren't going to be, those are out. Now, the good news, if there is a good news there, is those were probably taken out at the top of the market, especially if the individual was invested in equities before the equity markets have gotten hammered so hard recently. If you didn't, however, receive your required minimum until 2020, and this goes both for the ones that relate to the 2019 calendar year, as well as anyone who might have taken one already in 2020 that would otherwise be due by the end of 2020. Those are by definition under the law not required minimum distribution. So what does that mean? What it means ultimately is they're like eligible rollover distributions. The way the law is structured, it sort of pops out the part that makes a required minimum distribution not rolloverable and says, well, effectively that exception's not there, so we come back to saying this is an eligible rollover distribution. Practically speaking, what does that mean? It would suggest that you have 60 days to roll it over from the time that you received it. So standing here on April 15th, if you received a required minimum distribution or something that was intended to be a required minimum distribution sometime after the middle of February, it certainly looks like that is an eligible rollover distribution at this point. It could be rolled back into the plan or to an IRA. In fact, the way the law has worked on these in other situations, you can roll it back to where it came from. So what's the deadline for doing a rollover like that? At this point, it would appear to be 60 days, much like if you took a distribution in cash from your retirement plan and decided to roll it over. The good news here, of course, is that unlike the distribution that I described, typically if you took a distribution in cash, there would have been 20% automatic withholding to the IRS. So if I took $1,000 out, $200 would have gone to the IRS. And in order to complete a rollover, I'd need to come up with another $200 to make a full rollover. Here, if you took a required minimum or a distribution that was intended to be a required minimum, there wouldn't have been the withholding. So if you had $1,000 required minimum, you'd have $1,000 to put back in. One other thing that sort of catches us, by the way, here is we look back to 2009 when, as you know, those who've been in the industry and the working world for a while will recall, the markets were absolutely crazy right about the same time way back then. And so people were required to take distributions from their plan, especially people who were getting their first one, at a time when the markets were absolutely through the floor. The IRS conveniently back in 2009 said, in guidance that came out late in the year, we're going to waive the deadline for rolling these back over as long as you roll it over back into the plan or an IRA by November 30th of 2009. So these are some people who might have received distributions like in January or February of 2009, or out of the blue, and all of a sudden given the opportunity to roll these amounts back into a qualified vehicle, an IRA or a retirement plan. We'd be hopeful that the IRS would come out with similar guidance this time around, but yeah, again, wait and see on that sort of thing. Effects on 5-year payouts. The question here is, how is this going to work? Effectively, what it's going to do is it's going to give you 6 years to decide whether to receive your full distribution of the account. So these are payouts that would otherwise need to be paid no later than 5 years. Now they're going to be required to be paid no later than 10 years. A little interesting when you overlay this with what changed with the Secure Act. I think the IRS has got a little bit of homework to do here to help us all understand exactly how that's going to work. But the short answer is if, for example, your 5th year of a 5-year payout from a required minimum was going to come due by the end of 2020, you're going to have till 2021. And frankly, any other payout that would be being made over 5 years, you're going to get that extra year. Effects for like post-death distribution. These are a little bit interesting, and again, an area where I think we will make a prediction, but this is a prediction. It will be subject to whatever the IRS ultimately says. Again, the way the law is written on these, so take someone who's receiving distributions over the life expectancy of an individual that locks, so to speak, at the individual's death. So let's say right now there's 10 more payments based on the participant's life expectancy at death. Ordinarily, that would be paid out in installments over 10 years, 1/10 this year, 1/9 the next year, 1/8, and so forth. The question is, do we get a bonus year for that? Read literally, the law doesn't seem to allow that, but what the law would allow you to do is not take required minimum this year. So what would that mean? Well, it would mean that next year, instead of, you'd take 1/9 of the balance, the full balance. So let's say you had 100,000 today. Ordinarily, you'd get 10,000 this year, and assuming no increase in value, 10,000 next year and 10,000 each year until it was fully paid out. Again, assuming no earning or no adjustment for earnings, instead of getting 10,000 this year, maybe what we'll see is that you'll get $11,111 next year, and then $11,111 the year after that. It's not a terrible result. It does gives people the chance to have the market rebound, which is really the goal of deferring people being required to take distributions at this point. So we're somewhat hopeful that the IRS will be generous here, but really even the worst case scenario about how this might play out is not too bad, and especially in light of the fact it looks like rollovers are going to be an option. Let's see here, next slide. All right, next slide. I hope I can move to the next slide. There we go. Treatment of leaves, layoffs for, oh, I think I jumped 2 now, didn't I? All right. There we go. Treatment of leaves, layoffs, and furloughs. What's the difference in these terms? There is not a legal definition of these things, generally speaking. But usually what furlough is interpreted to mean is a shorter term rather than a longer term type being not at work. So could a partial termination be triggered? A lot of discussion about this in the employee benefit attorney and practitioner world here. So partial termination would be potentially result in full vesting if you had over 20% of your employees lose their ability to continue vesting, which is generally because they've been terminated. They're not going to be able to vest anymore once they terminate. I think it's our view, and again, I always certainly welcome Carolyn's comments as well on this, that a furlough isn't really intended to be a termination. And layoff, that term has a lot of different meanings, whether it means a real termination or not. Leave, same thing. If it's not a real termination, but more just we're not having you come to work right now, we think having 20% of your workforce temporarily not at work, we'd have a pretty good argument that you didn't have a partial termination in full vesting in that situation. Now, if it turns out that you don't bring the people back, there is a possibility. And again, what happens then is the people who were terminated during the year, in this case, like 2020, anyone terminated during the year would potentially jump to full vesting. I think that'll be a cross the bridge when we get to it kind of thing for most employers. In particular, it will be to the, after we see it, and hopefully employees will be back at work in the not too distant future, and this will be more of a temporary thing rather than the permanent reduction in workforce.
Yeah, Mike, I agree. Yeah. Oh, Mike, I was going to say, I agree on the furlough as long as if people are suffering employment and actually laid off indefinitely, then you would start looking at this. But for the temporary furloughs, we're not thinking it's triggered yet, but it is something to watch out for. Yeah. I just know it was with the time. I was going to say we might want to switch it over to John soon. Sure.
Okay. Let's see. I'll hit just a highlight or two, and then John, we'll jump over to you. Okay. So just 1 or 2 other quick questions we get. Do these type of things require our plan sponsor to make distribution or allow it? The answer on that is, if they're really terminated, yes. If they're not, probably not, unless they have another separate basis, like the coronavirus-based distributions. And as far as do the various leave payments count as planned comp, the general answer there is, if your leave payments and sick leave, that type of pay would otherwise count as planned comp, we think the advisable thing would be to include it. There are some opportunities and options there, but the general rule is that it would be included there. I think we'll go past this slide, and at that point, I think, Carolyn, there may be one more slide for you if there's anything we need to add there. Tax amendment deadlines.
Yeah, just a quick note. There have been some extensions by the IRS of different filing deadlines. It's not as helpful kind of on the plan side as it is for individuals for their tax returns, because what we're hoping for is that the calendar year 5500 deadline would be extended. That hasn't quite happened yet. But just to note that the changes that you're making, most amendments are not going to be required until 2022. But if you're making changes to contributions, or you need to add a loan program, some changes may need to be adopted early in 2020 yet. So with that, I will hand it over to John to talk about some of the health and welfare plan issues.
All right, thanks, Carolyn. Thanks, Mike. In terms of the health and welfare plan issues, there are some different considerations here that I'm going to be walking you through just as soon as I move this over here. One of the main questions we've been getting is relating to health plan eligibility, if you have a furlough or a layoff or something like that. And the main answer, kind of the typical response from an employee benefits lawyer, I guess, is look at the plan. So, your plan document is sort of viewed as a contract under federal law. And so if you, under the plan/contract, provide that they're eligible, then they're going to be eligible. If they lose eligibility, then they lose eligibility. And there's 2 basic structures in terms of how this can happen. For example, if you have a forward-looking test for eligibility, so if your plan says if you are scheduled to work 30 hours a week in the future, or if we anticipate you working 40 hours a week, whatever it is, that's forward-looking. People will lose eligibility very quickly if you're cutting their hours. If you have what I call a backwards-looking eligibility term, like the employer shared responsibility rules have this look-back measurement method, where you look backwards over a 12-month period, and then people become kind of locked in for a 12-month period. A reduction in hours here in April of 2020 may have no impact whatsoever on folks' eligibility. So again, you got to kind of walk through how you have set it up and work through those details. If someone is eligible and if they're not being paid, how do they pay for coverage? That's an interesting question. We know that some employers are looking to provide basically loans, if you will, where they say, hey, we'll cover you employees and then you repay us back later. The question is, what if the employee never repays it back? Does it become taxable wages? What if the employee never shows up again? They moved on, they quit. You didn't even know if they're going to be quitting. So lots of different kind of permutations like that. If you actually have a true kind of severance of employment, a true layoff, I guess, COBRA would normally apply. COBRA can also apply, of course, if you have reduced hours, a reduction in hours which cause the loss of coverage as a COBRA qualifying event. If you're not happy with these terms, if you're self-funded, probably modify them. If you're fully insured, maybe talk to the carrier about it and see if they'll agree to some kind of change there. Same analysis, unfortunately, for your other welfare plans, so not just medical or dental or vision, or health FSA, HRA, things like that. You have to, I think, look at every single plan, because every single plan could have different eligibility terms. So life insurance, long-term disability, short-term disability, AD&D, accidental death and dismemberment. So again, you have to kind of go through all those and figure out, okay, what is the result? Are we happy with the result? If we're not happy, let's modify it. Also, in terms of other legal changes here, the Families First Act, as you probably have heard, requires all group health plans to cover certain specified testing during the coronavirus emergency period. Very restrictive in terms of plan design features here. You can't impose any kind of cost-sharing requirements, no co-payments, no deductibles, no co-insurance, no prior authorization, no other medical management requirements. And that, again, seems to be intentionally broad and restrictive on the ability of a plan or an insurer to really make exceptions. So, for example, we have some clients that don't allow for out-of-network coverage in general, except for like emergency care or other legally mandated coverages. This probably doesn't allow for that kind of restriction. You probably have to cover it even if it's out of network. Same thing with medical necessity. A lot of plans say we're not going to cover it unless it's medically necessary. What if you have somebody who, in a couple months when testing is more available, what if they go in for a test every single day? What if they go in multiple times per day? It's probably not medically necessary to be tested 3 times a day for this coronavirus, but under the plan, you can't impose a medical necessity requirement. So it looks like the plan has to pay for it. Again, right now, it's not really an issue because we don't have the tests. So again, you're not going to have someone getting tested multiple times per day. But I guess the threat is out there, if you will. Also note that coverage of testing and treatment on a pre-deductible basis will not destroy the high deductible health plan status. So that's very helpful. I also want to note that for some employers, you'll be able to get a tax credit for various payroll expenses, the taxes you're paying with respect to payroll. And as part of that, you can also throw in the amount that it costs to provide and maintain a group health plan. We weren't sure how this was going to work, but there's some new IRS FAQs from March 31st, which give us a nice little example. Note that most health plans will be able to take this credit. Most health plan expenses will count, and it's available for employer contributions and employee pre-tax, but not after-tax contributions. And basically what the employer does is they allocate their health plan expenses on a per employee on leave per day basis. So, for example, suppose that Acme company has 400 employees on a fully insured plan. They pay $5.2 million in premiums in 2020 to the carrier. That total of $5.2 million is divided by 400, the number of people on the plan. Let's assume that they're all on the plan. That gets a $13,000 premium per employee. Then you figure out how many days those employees worked, and there's a calculation, basically 260 days, I think would be the standard there. And then you figure out what the cost of the health plan is on a per day basis. So you take 13,000, you divide it by 260, and again, that's $50 a day. And then that $50 per employee per covered leave day for each day that they're on the leave is the qualified health plan expense that you can claim as a tax credit. If the plan is self-funded, you would use a COBRA or similar actuarial estimate. Other considerations, CARES Act. So builds upon the Families First Act, but also goes beyond it. For example, it tweaks the definition of what exactly has to be covered from a coronavirus testing perspective. So if you modified your plan based upon the Families First Act, say, okay, here's what we have to cover, you now have to update it, unfortunately, based upon the CARES Act, because there's some kind of technical changes there. It also establishes what a self-funded health plan must pay for coronavirus testing. Basically, if you have a negotiated rate, that works. If you don't, you have to look to the healthcare provider's public internet website or, again, try to negotiate it. If and when a vaccine or other coverage becomes available, such that it constitutes preventative care, then in general, health plans are going to have to cover it very quickly within about 15 calendar days. Again, most folks anticipate that this will be, a year and a half, maybe 2 years out, perhaps, in terms of when we actually get a vaccine. So not anything you have to worry about today. The CARES Act also removes the ACA limitation on health FSA, HRA, and HSA reimbursements for over-the-counter medicines. This is an optional one. You don't have to do this one or a related one saying that menstrual care products can also be reimbursed. But we think that most employers will want to do it. We think most employees will want you to do it. So we do think it'll be popular. You can also do it on a retroactive basis back to January 1, 2020 if you want, or you could just do it on a going forward basis or somewhere in between. But again, probably talk to your administrator at that point to see what they're capable of doing. A couple other little tweaks. There's some new regulations that came out last week, which said that in general, if someone is on one of these new paid leaves, the sick paid leave or the family leave, that you have to maintain health plan coverage during the leaves. The basic approach is to follow the FMLA rules. That's fine. I think most employers are used to those. Have employees prepay or pay as you go or catch up later are the standard options there. There are a couple sort of weird things in there. For example, in addition to relying upon the FMLA, the agencies claim that this is also required under the HIPAA non-discrimination rules. That's sort of a weird position. They've never really said that before. It raises some concerns about whether, for example, it would apply to smaller employers, less than 50, who are normally exempt from the FMLA old rules. Also, whether it applies to leaves beyond the FMLA period. So it just raises some interesting questions. And then there's new FAQs that came out on April 11th that say that the agencies would take enforcement action if an employer or insurer attempted to limit or eliminate other benefits to offset the cost of coronavirus testing. So sort of an odd one. Keep that in the back of your mind. Other little tweaks, the loan program here allows for health plan expenses to be taken into account. You can get a loan for health plan expenses. CARES Act allows for telehealth and other remote care services to be provided by a high deductible health plan, again, without destroying HSA eligibility. On the non-health plan side, you can adopt kind of a new program to pay for certain employee student loans. It's a nice feature, but it does expire at the end of the year. And also take into account cafeteria plan changes. We've been getting a lot of questions about can dependent care elections be changed if all the dependent care providers shut down, and the answer there is probably yes. Tougher, though, to modify health FSA elections is what we've been finding. This slide just has a couple links to other pieces of guidance you may want to look at for additional updates. And I know we're tight on time here, but Mike and Carolyn, I think we might have time for a question or two.
Yeah, and thank you, John. I think that's right. So for those who need the credit, it is 11:59. I think you probably are reaching your credit requirement. But yeah, we have 5 or 6 questions here, which I think we can go through in short order. Carolyn, if that's okay with you as well. I have a few. I think there's a couple for Carolyn, and 1 or 2 for Carolyn, and John, I think there's 1 or 2 for you that have just been coming in during your portion of the presentation. So I will address them, I guess, in the order they came in. We talked about implementing temporary pay reductions, and then the next one. Are we required to tell employees about their options for withdrawals, loans, distributions under the 457 plan, or do we count on them to find out about it? I've actually had this question from a client, and my inclination is yes. You should do it. If you want to be sort of very legal as to what the requirements are, there may be some time to do it. But I guess our take, I think at Quarles, I'll speak for all this, but Carol and John certainly correct me, is that if you're going to offer these things, you really are offering them because you feel people would have a need for them and make it a desperate situation. That said, there's nothing to prevent you from, when someone requests these distributions or as part of your notification, expressing to them the sentiments that we have had concerns about, which is if you're taking money out, you're taking it out at the bottom of the market. You're taking this out at a time where it could have a long-term impact on your retirement planning. So be very careful and think carefully about whether or not you want to do this and whether the timing is appropriate for it. It can be a difficult situation, but we want to also make sure you're not doing something just for an improper reason. Question about the 10% penalty for distribution, and the slide is inaccurate. Just to return to that very quickly, the 10% penalty on distribution would be waived. It would not apply for a coronavirus-related distribution. But where it would potentially still apply is if a distribution is being characterized as a hardship. And the only reason, I guess, that strikes us that you would characterize it as a hardship at this stage is because you used up your $100,000 worth of distribution, or because you simply can't qualify as a coronavirus-related distribution based on the technical requirements of being a coronavirus distribution, but you otherwise still qualify for a hardship, in which case the 10% penalty would still apply. So apologies if the slides are unclear on that. That's certainly the message we were trying to relay. One more for me, and then I think I'll flip to Carolyn here. Could you take a distribution which is treated as a rollover and roll it over into a Roth IRA? So the question I think is, could you take the distribution as a coronavirus related distribution, and then when you repay it to a Roth IRA? I suppose that's possible. I don't know that we've gotten clarification on that. The answer is, I think that's probably correct. I suspect that might not have been in the minds of the people working on it at the time. So, the way the law works is a distribution, a coronavirus-related distribution, when it's repaid, is treated as a as a direct rolloverable distribution. Carolyn, would you be able to address the question on Form 5500s?
Sure. So the IRS has not approved a filing extension for 5500s for calendar year plans, which are generally required, on July 31st. If you had a plan that was a fiscal year plan, not a calendar year plan, and your filing deadline was in April or May, then you have an extension until July 15th. But for regular calendar year plans, it hasn't been extended. But you can still follow the normal procedures to extend it as far as filing I can't think of the number now, but the extension form, and you could extend it that way.
Okay. John, I think you have a few questions. I don't think there's any more for Carolyn and me at this point. John, I guess if you can address the questions that you have time for, and then we will probably be wrapping up. So, John?
Okay, sounds good. The first one is the Families First tax credit only for companies with less than 500 employees? And I believe that the answer is yes. I've not heard of exceptions for folks who are bigger than 500, so I think it's less than 500. Can I confirm if the medical credit, the tax credit calculation, includes the employee contribution to an FSA? And I believe that the answer is yes, as long as it was made on a pre-tax basis. And the reasoning behind the IRS, I think, there is pre-tax, like cafeteria plan contributions, are technically viewed by the IRS as employer contributions. The employee elects to reduce their wages, and then the employer, in exchange for that promise, makes an employer contribution. So even though it feels like an employee contribution, it's technically viewed by the IRS as an employer contribution. So I think it does count there. If the dental or vision is 100% employee paid with pre-tax dollars, can these be included in the medical credit? Again, yeah, you can have, oddly enough, 100% employee paid in quotes, because again, technically the IRS views it as the employer paying it, and so that again does work. So with that, I think that we're kind of out of time here. so
Okay.
we'll probably just wrap it up if that works for everyone. Mike, any closing comments, or Carolyn?
No, thank you very much for attending today, and we look forward to kind of being there for you and helping you through. So best wishes in this time, and hopefully we can be further assistance, and hopefully you got some good information today. Carolyn, John?
Yeah, no, thanks for attending.
Yep, thanks everyone.
Bye now.